was the inclusion of the creative sector in those guidelines for preferential treatment. Why is that important? Honorable Minister Rakhari, in responding to the budget speech 2021, mentioned that the creative industry currently in Botswana contributes 5.5% to Botswana GDP. Now that is extremely important because it's actually higher than agriculture and comparable to other industries like construction, transport, and communications and manufacturing. So this is a very, very big industry, which we should be putting a lot more focus on Botswana. Ramasisi as well, President Masisi has also declared that he wants Botswana to move to a knowledge-based economy. And this particularly moves the creative sector front and center on creating jobs. So as big as this industry is, and as much effort as we've seen and a lot of talk that we've seen, we now need to make sure the creative industry is front and center. And it's quite great, Hobana CEDA, focusing on that and including it in the guidelines. And that's a step in the right direction. So hopefully, it will not just be 5.5% of GDP, but we'll also see creatives being 5.5% of funding in companies like CEDA. Now, just to give a little bit of background, we need to look at the kind of sectors that are included under this dispensation. So we're looking at things like arts and craft, bataiki, baopedi, television, radio, those YouTube vloggers and bloggers, comedians, bodona, lebo mele, basigi, le ditiro tse dingwe tsa setso jaaka go loga ditatana jalo jalo. But this also includes professional services like architects, graphic designers, websites, software designers, jalo jalo. And all of these relate to something called intellectual property. And that's where we're going to start. Now, to give us a breakdown of what intellectual property is, I'm not alone. Letlhogonolo Moremi. Yes. And
thank you so much, Mphoeng. Letlhogonolo Moremi. I am an intellectual property law consultant and a creative development practitioner. So the bulk of my work revolves around, firstly, the creative sectors and building creative economies, rather, on the continent and across the globe. It's work that I've been doing for a little over 7 years now. And then in November 2019, I founded Park Grey IP, which is an intellectual property consultancy based in Botswana.
So the work in that space around sort of the creative sector and intellectual property.
Of course. I think there's great potential, especially here in Botswana and on the African continent, of course. We've got the opportunity to host a workshop around that in Tanzania last year. And we're trying to build a pan-African network of intellectual property creators. And I think it's also worth noting that, the African continent is the youngest continent by age. We have the youngest population the world over, and that's where the best ideas are. That's where the innovators are. So we have this huge resource that, if we set up the right structures, if we set up the right frameworks, could be what pushes the continent towards an economic shift and economic change. Yeah.
So we're going to now jump into what IP is. If just drop your questions on the chat, in the Facebook chat, and we will take them from that side and answer them as we go along. So if anybody who doesn't say just ask us a question and we'll clarify. So let's start.
Right.
In layman terms, for Motoko Kolapeng,
right,
how would you describe and how would you define intellectual property?
Right. I think the easiest way to describe it would be to say intellectual property is creations of the mind. That means that these are things that you create with your creative labor. It's solutions or products or art or music that you create by applying your intellectual faculties and then producing a result like that. For example, if you sit down, there's a lot going on TikTok nowadays, right? So somebody sits down, thinks of what could make people laugh, right? Puts together a sequence of movements, adds some music to it. That end product, what the rights that come about in that product, is what we would call intellectual property. And I think it's also worth noting, because a lot of the questions that I get in my work is, how do I deal with an idea XYZ? And I think it's worth noting that when we talk about intellectual property, it does not necessarily deal with things that are not created. So for it to be intellectual property, it has to be created. So if I have a thought in my head about a cure for an ailment, it is not necessarily intellectual property until I put it down maybe on paper or produce a chemical sequence or whatever it is that I need to be producing for that to materialize. That's when the protections that come about from IP can then start kicking in.
So we always hear that complaint, somebody stole my idea.
Right.
So if we met and were over drinks and you told me something or what you were thinking about, then effectively, if it's just an idea, we sue the recipe.
Right.
It's not intellectual property.
Not necessarily. I think that it's worth noting that there are so many different facets to intellectual property. There are so many different types, and information itself is a type of intellectual property. So then if I disclose something to you, then there are certain rights and obligations that arise in a scenario like that.
Yeah.
If you take my information and you use it because I myself have not put it down on paper, there are some legal ramifications that could come about from that.
Yeah, and I mean, I think being on social media, we've seen a lot of those fights around someone writes a joke and then somebody sort of steals it and paraphrases it and runs with it, or like you gave Mobo TikTok.
Yeah.
We've seen some comedians in different parts of the world.
Yeah.
A guy knows that you're an SA, so he uses your joke.
Yes.
About go state. So that kind of thing is
that sort of thing. Exactly. So it's really just about, I think at the core of it, it's about making sure that people who apply their time and apply their resources to create these new products and to create these new ideas, creations, expressions, it's about making sure that they are able to benefit from their labor, both in the sense of being able to be credited for their labor and both in the sense of having rights over what can be done in a financial, economic sense with that product of their labor.
Yeah. So you mentioned types. There's many varying sort of scenarios.
Right.
So, can we go into like some of the types of how intellectual property effectively gets protected, Jonathan?
Right. I think, there's, of course, different types of intellectual property, but just to run through the most common ones, you have rights that are known as copyrights. So these are rights that attach to artistic and creative and artistic expressions. So these are things in the artistic sphere, in the literary sphere, in the sense of music, in the sense of paintings.
How literary? I mean, you mean writing?
Literary, yes. Bodibukaja, nabomaboko, that sort of thing. So protection in terms of copyright then applies to, like I said, things that have already been created. It applies by the effect of their creation. And I think it's also important to note that intellectual property laws differ from country to country. But as it applies in Botswana, if ke kwadile buka, ebe ke publisher, then it's a work that is protected by copyright. I have a set of rights known as copyrights that subsist in the work.
So if you see that sometimes you see that little C at the top. That means that's copyright protected, right?
Yes, that little C is protected like a copyright. And basically maybe just to backtrack a bit before going into the other ones, what these rights do, intellectual property generally, they give a right to the right holder to prevent other people from using or exploiting that product, right?
Yeah, earning money.
Earning money off of it. So if I make a this machine here today, and it's my intellectual property, you can't go and reproduce it or resell it or trade in it in any way without my consent. That would be an infringement of the of my intellectual property rights regarding that. So same thing applying to copyright then. If I publish the book, then you can't go and make copies of my book and sell it just for your own benefit without my consent. So again, it's about making sure that the creator benefits from the production, from their creative labor. And then moving on from copyright, you have what are known as trademarks or brands. These are maybe words, signs, designs that are used to distinguish one product or service from another. So, for example, the CEDA logo, right? If you see the symbol, you know that it's CEDA, and it's the CEDA trademark. So when you see it, you can distinguish it from the next organization. And when you associate, when you look at it, you associate it with certain things, which is where brand value comes in. So when it comes to trademark, it's about protecting your business as an enterprise and the value of that business, so that I cannot come and then use something that is similar or something that confuses people to thinking that this is my work, or me using your name without your consent. And then we have a lot more. We have patents. Patents apply to technological and technical solutions. So, for example, the people who made this particular device probably have a patent on the design of it, probably have a patent on how it functions. So basically what it means is no other entity can use what they have done here to either create their own or to profit on their own.
Yeah.
And I think one interesting thing before wrapping up this particular answer is to note that in Botswana, the Industrial Property Act provides for protection of traditional knowledge. So it means that if ole moholo ko lapeng o itse gore setlhare sengwe se bereka jang se dirwa jang wena o se kopanya yang gore se dire eng, you can register that as traditional knowledge. Now here, traditional knowledge, because it's largely communal, usually it would be registered by the user or a community of people who use that knowledge. Ha nna lo ena re itse gore modu a setlhare sengwe re o dirisa yang, we can approach the organization that is relevant and then register that, so that somebody can't come outside atla gore tsela yanong se re se dirang.
So borre ba ko dibete baka tsa that, and e ba nna gore nya ra ha le gore ga o tswe mo dibete o ka se kwa tsenya solution a go mo sekupung yana sa coke. Yeah. And I guess that goes to even techniques tsa bogolo ga ditatama,
Exactly.
and all of those kind of things, and techniques tsa basket weaving helar.
Exactly. Yes.
Okay, good. I think we've gone through a few. So you were saying IP effectively suggests that the creator owns the work of the creation.
Right.
So how does one lay claim? How can you then say nya monelena? Because obviously, like Narubua, sometimes when you things like ideas, we tell a lot of sometimes this a problem at the same time and come up. How do I make sure make and be able to lay claim to something like that?
I think that depends entirely on the type of intellectual property that you are producing. Firstly, I think there's copyrights, of course, that applies to, like I was saying, literary and artistic works. Regarding those, there is no need for you to say you are registering this thing in order for it to be protected. I understand that, of course, we have a registry office here in Botswana, but that serves an evidentiary purpose to say at particular date and time, but if I've written a book and then somebody infringes on my copyright, maybe by selling my book without my consent, those are rights that I'm able to enforce against that person without having to say, is this a registered thing or is this not a registered thing?
And I guess that's important, especially now with social media. You can imagine maybe they write stories online and just puts them up on Facebook.
Yeah.
So what you're saying is, if Nakatama and I take down all of their stuff, create, maybe this person is a poet, has been putting up their poetry.
Right.
I go there, I pick it up, anthology,
Yes.
they don't need to show, as long as their page is there and it's clear, they don't necessarily need register somewhere else.
Right. All they need to show is that it was in fact their creation at that particular point in time, and then those rights can be established from there. And then I think moving on to the other types of work, because as I was talking about the copyright, there's what we've come to know as industrial property. So that relates to patents, that relates to trademarks, that relates to things like utility models. So these deal more with the commerce aspect of things. So these are things that have commercial application, like I was explaining what I can trademark ke go differentiate the service tsa me go tswa mo go tsa gago. Patent ke gore ke protect the product there me so that you can't use it. So a lot of those then would require registration in order to be protected as such. For you to say you have a claim and a trademark, you would need to register a trademark. For you to say you have a patent to protect, you would need to have a patent registered. So then if we come across the same solution at the same time, and you have registered your patent and I have done nothing in that regard, I stand kahamusinyano, because you are able to demonstrate what at a particular point in time you did 1, 2, 3, and it is in fact your work.
Yeah. So bringing it back to effectively why we're here and CEDA and monetizing the intellectual property. The reason why I think earlier in the year, July, when CEDA launched the new guidelines, where it suddenly became a thing of interest,
right,
was that we were told you could potentially use your IP to as security for a loan.
Right.
So I think I want us to drill down on that a little bit more, on what are the kind of things that we need to worry about there. So for argument's sake, does that mean for the rest of life no one can use that pina, that melody? Well, things like that.
Right. I think it's important to begin by saying a lot of the rights that subsist in intellectual property are not perpetual, so they don't last forever. They are protectable for a certain period of time. What happens in that period of time is that you are the one person who has the right to commercially exploit that. And I think it's important also to say, when you produce a song, or when you produce a trademark, or whatever intellectual property you're producing, you are in fact producing an economic asset. You're producing something that has value. You're producing something that can be sold. You're producing something that can be rented. So you are producing something of economic value that should in effect be treated as such. And then when you think about it, it's about what really makes up intellectual property. You find that, okay, there's the legal aspect of, does it meet the legal requirements? It's a copyrightable work, or is it a patentable work? There's also the economic aspect. Does it in fact have economic value? Is it something that when you put it on the market can be sold? When you put it here, can I say, oh, I would like to buy that? Or is it something that carries no value in the market in the sense? An interesting example is the case of escalator. Escalator used to be a trademark. But
escalator, the word?
The word escalator used to be a trademark. So somebody had the rights to say, I'm making an escalator, and nobody else can say they're making an escalator.
So if you were going to make that same steps, you had to use a different name?
Probably, yeah, had to use a different name. But the trademark then lost value in the market because of how the market took up the word. So now escalator is not really something that you can benchmark on. I mean, the word itself can't really benchmark on that as an intellectual property.
So now it's just another noun.
It's just another noun. It doesn't carry much economic value. So those are the two distinctions that we need to be aware of when you think of what makes up the economic value of a particular piece of intellectual property.
So an important aspect as it relates to funding,
Right.
Valuation. Whenever if you are getting a loan as security, you have to value it.
Right.
And there's particular different ways of looking at that. What do we then look at, and how do we consider valuing intellectual property? Like, how does one value their joke? How does one value the video, their TikTok video, for argument's sake?
It's a very complex issue because it depends on so many factors. One of which is really why the valuation is happening. Are you valuing because you are trying to raise funds? Are you valuing because you are insolvent and you're trying to get rid of assets that you have? Because that, in effect, is going to affect where you lend on the numbers. So there are several factors that you consider when you conduct a valuation of intellectual property. Things like the legal issues surrounding that particular piece of property at the moment. Is it something that's being litigated over at the moment? Because that, again, affects the value. Issues around what is known as freedom to operate. Does your intellectual property run the risk of infringing on somebody else's intellectual property? So if you're putting it down to say, I want this valued rather, it matters whether you have free reign to economically exploit this piece of property, or you have limited range to exploit it because you might run into some gray areas with other people's property.
Give us an example there.
So, for example, there was an issue recently in Botswana of two ladies who were competing over a name, in essence, assuming that that name would be a trademark.
Yeah.
Given the assumption that that name would be a trademark, and somebody wants to maybe use whatever income could come from that trademark as collateral. So then when we conduct the valuation and we say, but when you use this name, you run into 1, 2, 3 issues. So instead of it bringing X amount of value or X amount of pulas in a month, it effectively could cost this much because there are landmines that we have to dodge along the way.
Yeah, because you might get sued.
Because you might get sued, things like that. So then that brings down the value of that particular piece of property. And then there's also the issue of what method are you using to conduct your valuation, because there are different ways of trying to calculate how to value a piece of intellectual property. So some methods will give you a higher value, some methods will not give you a much higher value. But again, it's this merger of different complex factors that affect where in the end you land on the numbers.
Yeah, and I mean the valuation and the method of valuation that we have is something even lerona in just normal financial markets,
right,
we normally have an issue with.
Right.
So, what methods are there when you look at economic valuations, and how does one think about it? So someone being if I'm to value my IP, what options are out there for them?
Right. I think it's important to start by saying that when you conduct the valuation, because intellectual property is in effect an intangible asset. So what you are looking for is you're looking for a way in which you can give the person who's giving you finances assurance that they are going to get back money on their investment, right?
Yeah.
So then different methods then can apply to different kinds of intellectual property and different kinds of investment issues, right? So firstly, you'd have what is known as the cost-based method, right? This method basically, it hinges largely on an assessment of how much it takes to develop that particular piece of intellectual property. For example, if you have, pharmaceutical companies like Pfizer's, your Pfizer and your likes, would then say, okay, we need to access this much funding in order to develop a particular product. We approach a lender for financing, and we put it on the table that, okay, for them to give you this particular property as collateral, this is how much it takes to develop it. So what you're basically putting is the value that it took to develop that particular piece of work.
At a layman sort of way, similar to if you could, your baseline valuation could start with this is how much I built the house for, so give it 100,000, right?
Okay, yeah. Great stuff. Exactly. And then, you'd have more of what is known as the market-based method, which then applies to, because like you were saying, your baseline valuation may be 500,000, but between you and me selling the house, I may be able to buy it for 750,000, depending on whatever considerations we are having between the two of us.
Yeah.
So then that would be the market-based method. It's based on looking at similar transactions. It's based on looking at what is a willing buyer willing to pay for this particular piece or for this particular product.
Yeah, Lorna, in financial markets, what was the last price a particular share was traded?
Right, exactly.
So that's the valuation on that specific day.
Exactly,
so, yeah.
exactly. See, I like how you keep bringing that in, because it brings it home that it's really a piece of property, a piece of an asset like any other.
Yeah.
So I like
and
this
it's
comparison.
Not as complicated as you guys try to make it seem.
I would love for it to stay complicated. But no, I think, and then moving on to the third method would be the income-based method. So this is usually more than applied in the creative sectors, and this is usually applied in the case of seeking funding within that context, where what you are putting down is basically the future income of a particular product, right? So I'm going to make a movie. I need X amount of money to make the movie. When I approach CEDA and say, okay, I'm going to make a movie and I need X amount of movie, what CEDA would want to know is how much is this movie going to make? Because how much that movie is going to make is how much they will be able to recover on their investment. So the method then depends on the income that is going to come after this IP is developed as a way of recovering as a way of ensuring the return on an investment.
Yeah, I mean,
right.
I think that is probably particularly applicable since in the past few years, we've seen quite a lot.
Right.
When Now TV and all of these creators of series, but
Yes.
they end purchase them at a particular price.
Yes.
So I guess that would be something like that, where you'd say,
Yes.
I'm going to make this series for 200,000, but Hakirex is a BTV, it'll be $1 million.
Yes.
So
Yeah.
maybe doing a valuation that way.
Exactly. Because at the end of the day, it's about how much can the lender be able to recover. Because the issue becomes what happens when you don't have money, right?
Yeah,
what
to
happens
to pay back
the loan. So the lender needs to be in a position where they are assured that this particular product has enough money for them to recover on their investment. And I think also let's note that intellectual property, unlike other forms of property, does not have a ready market where you can say, okay, if you don't pay back the loan, I seize your house and then I go sell it.
Yeah.
If I have a 2 million pula Rembrandt painting, it's not a market there's no market that's ready to say, okay, I'm going to take this painting for 2 million pula. Or if I own rights to somebody's catalog, it's not like there's a market that's ready to say, I'm going to take this. So there are all these considerations that need to be put in place. Whichever method you apply, whatever factors you're considering, all of these things need to be put into perspective to make sure that whoever is financing, whoever is financing that particular transaction is in a position where they know that they can be able to recover in the end.
You made a reference to a catalog, and I think something that would be interesting on the income-based method. We all always see stories that relate to people getting paid out of Bokos bots.
Right.
So is that what you're referring to? So an artist could effectively say, these are my songs. This is what I expect to receive from X from a particular thing. So ke batla gore ke o dinele a security. Maybe gore ke go, maybe gore ke go create a studio. Maybe fund me for a studio.
Yeah.
And then the music that comes out of that we can.
Yeah. I mean, it's exactly that, because what the artist is putting on the line is effectively the future earnings of the royalties that are going to be coming in from that that particular catalog. And speaking of catalog, there's a famous case. It was called the David Bowie bond. So what David Bowie did is he used the future earnings of his catalog, which was a little under 300 songs at the time, and this was sometime in the 90s, I believe. 90s, 80s. I get my dates wrong.
Yeah.
But it was, so what he did is he wanted a commercial loan. He wanted a loan from a commercial bank. What he did is he gave the rights to future royalties to this particular bank and said, okay, I own this many songs in my catalog. This is how much they're expected to make, and I need financing for a particular product. And I think through that transaction, he was able to raise about £5 million at the time, which was calculated based on this is how much, this is what's in your catalog, and this is how these are the royalties that we expect to come through your catalog over time.
Yeah.
Right.
Okay. Cool. So I mean, you've just sort of given a way of structuring. Right. The IP to be used as security.
Of course.
Let's go through a few of the methods like especially if someone wants to come and
right.
How can one structure the IP acceptable to lending institutions?
I think the first thing would be to, again, ensure that your house is kept, right? Make sure that you've done your valuation, you've structured your portfolio in such a way that you know what you own, you know what you don't own. Because the other thing about IP is you find that in one product, many people can have rights. So if there is a song, for example, you as the songwriter, as the person who wrote the lyrics, you have copyright over that. The producer has copyright over the arrangement. Somebody has rights over this. Somebody has rights over that. So make sure that you are aware of what you own and what you don't own. So that when you come and present, we know exactly what you own and how much it's worth.
Just how does one do that? How do we know what mobiles are not practically?
Right.
Would a guy come to you to say, come value my catalog? Where would he go?
Right. I mean, I think in terms of establishing what you own and what you don't own and the subsequent processes of valuation and the like, what you would need is then to have there are legal considerations, of course, so somebody with a legal background in that. I'm not talking about myself, but yes, I am talking about myself. Yes. Somebody that can help you establish where your rights lie and where they don't lie. And then, again, somebody that can help you establish this is how much how much this holds, how much value this holds in the market at the moment, and how much value it's likely to hold in future. So that would be the valuation process. So those would be the answers and the questions you would need to have in that perspective. And I think then moving on to the actual use as collateral, there are different ways in which you can have or you can use the IP as collateral, right? So I think the easiest one would be directly pledging it as collateral. So it's similar to, pledging your house as security, right? You say, this is how much this house is worth, or you say, this is how much my IP portfolio is worth or could be worth, and give me money. If I go insolvent, you take it, you dispose of it, you recover your
financial interest.
Right.
Locally, I mean, Mantura register deeds. Where would one register that kind of a collateral?
So, registering it as collateral, again, I think locally it's something that needs to be worked out, for example, because I think once we start entering into the terrain of using intellectual property as collateral, there are many other considerations that we need to take in place that I feel were not maybe yet perfect. We haven't yet perfected at the time, because there has to be synergy with the other legal frameworks that are in place, right? There has to be synergy with the other legal instruments that govern certain use of certain properties in certain respects. So I think that's something that is
working on it, yeah.
Working on it, and looking towards exploring. And again, speaking of houses, it takes us back to the issue of putting the lender in a secure position. Again, it's not like there's a readily present market for what should happen when I go insolvent and the lender has to take the property. So then using intellectual property as directly as collateral then may not be the most favorable method for our particular context.
Yeah.
Right.
So we talked direct collateral. Any other ways of doing that?
Right. There are other ways. There is what is known as IP securitization. So what happens there is we take that particular intellectual property or the rights to any future royalties or any rights that you are collateralizing at that time, and we basically transfer them to what is known as a special purpose vehicle.
So just a company for the
yes,
layman. Yeah.
It could be a company, it could be a trust, just a separate legal entity from you.
Yeah.
So then what the function of that legal entity is basically to protect against your own insolvency. So if I become insolvent and I have to divest of my assets in order to pay back the people that I owe, that particular intellectual property that I've pledged as collateral remains safe under the ownership of that company.
If you're an entrepreneur, put your assets into an SPV.
Right. Right.
Yeah.
So it's basically to create an insulation from your own insolvency. Again, it puts the lender in a better position. And then the royalties that the money that you get from collateralizing that, of course, will come to you and you can invest it in what you need, and then the income that you get from that is paid to the special purpose vehicle, and it services the loan basically.
Okay, so let me clear that up. So that's you form a company, you put the IP under the Kyone receiving all your cash, you go and get the loan against that particular company, and the income that goes into that company, Kyone duelang the loan effectively.
Kyone duelang the loan effectively.
Okay.
Right.
So I mean, yeah, just the same way as you would do for property or for anything like that.
You know the stuff.
I'm a finance expert.
Right. All right. And then moving on to like the other methods, there's what is known as a sale and leaseback method, where basically I would sell you the rights to my IP, and then I would so I sell you ownership of the IP for a particular period of time, but I retain the rights to use the IP. So you can own the brand, but I can use the brand in the meantime to generate income. That way I can pay you back. If I default, you maintain ownership. But if at the expiration date of the period, I'm selling you for a particular period of time.
Yeah.
If at the end of that period, then I've fulfilled my obligation, I have the option of buying back my intellectual property, and we part our ways on good terms.
Okay.
Yeah.
So fairly easy enough, and I guess those are all options. Going forward, if someone is interested in Mamadi, those are the kind of things that they would need to think about. Now, we've had a few questions on social media as and we'd like to run through them. So someone here has asked, what is the process of patenting your work in Botswana? So if you actually did want to protect them, how would you go about that?
Right. The process of patenting work, it starts with basically, firstly, an assessment of whether what you're doing is patentable. Sometimes we receive inquiries about, hey, I would like to do a patent of this, but then we have to advise the client, or what you need is not a patent. Maybe what you need is a trademark, for example. Maybe what you need is to register a utility model. So it's assessing whether it's patentable. There are certain requirements of what is patentable.
Do you want to touch on that? Yeah.
Of course, quickly run through them. Firstly, I mean, it has to be novel in the sense that it's something that is new.
A new use.
That
yeah.
That is a new or a new use of a particular thing.
Yeah.
It has to involve an inventive step in the sense that what is the innovation that you have added to that particular thing, right? What is the innovation that you have brought to this particular thing? And then it has to have commercial application. Where can we use it in commerce? Where can we use it in business? What economic value does it hold? So establishing that, and of course, is it in fact a technical business solution thing? Does it fall within that sphere?
Yeah.
And then once you've assessed whether it's patentable, then you basically do your research, do the patent search to find out if there are any similar existing.
Where would that search be done? CEPA?
CEPA is one organization that can help you with that, of course. There are other resources online that allow you to access patents globally. Resources like Patent Scope, or you could simply come to me and I will do it for you.
Yeah.
Right. But yes, resources like Patent Scope then would allow you to be able to figure out if in fact what you have hasn't been registered before. And then after that, you begin now filling out the process of filling out the forms, declaring what it is, what your innovation is, and then finding out whether a patent can be granted in your favor. I think it's important to note that the process of patenting largely hinges on disclosure. So when you fill out the forms and when you apply for the patent, you have to really explain, what it is that you have done, what it is it going to be used for, how did you innovate, why did you innovate, that sort of thing. So that a person who is in your field, when they look at that information, they can be able to recreate that thing, right? But again, the protection is, even if they are able to do it, they're not allowed to do it. The information is there for the benefit of, science and all of that, but they're not allowed to use it.
Okay, so I'll go back to the practical side of it, Mobotswana.
Yeah.
If I wanted to patent something, so I'd probably need to get a lawyer like yourself, so like an intellectual property lawyer,
right,
who would then walk me through that process.
Right.
What are the costs for things like that, like when we're registering patents and and all of that kind of stuff?
I mean, there are different fees there's a distinction between whether you're registering as a big company or as a small, as an individual or a small company. I think there are fees that I can't really specifically remember right now, but all of them I think at each stage I can definitely say for an individual would be less than 300 pula, for example, to file the registration, maybe pay 90 pula for the publication fee, and then pay around maybe 250 for the final registration. So again, it's a lengthy process that could take up to like 18 months because there's various assessment that needs to be made at various stages to assess whether or not a patent should be granted in your favor.
Okay.
Yeah.
I think there's a question on how to value the IP, which I think we've touched on.
Yeah.
Do we have any other questions? Okay. But in the absence of other questions, I would say, I guess let's wrap it up.
Right.
It's been a very interesting conversation, especially for me, realizing that a lot of this stuff is just finance, right? And stuff that I think a lot of people already know and already knew.
Right.
What are your final thoughts, especially practically to people out there who would like to take this step? What would, outside of them obviously coming to you, what kind of advice would you help them with?
Right. I think I think the information out there is especially on the practical steps of what to do when you need a patent registered or when you need a trademark registered. You know, the CEPA website is very informative about that. I think also there are many resources online that people can find that explain exactly what intellectual property is and what applies to what. I think I need to start with that particular point because the biggest problem that we've seen since we began operation is that there is lack of knowledge. So informing ourselves is the most important step. And then after informing ourselves, the second most important thing I would say is to understand that what you have is an asset. I understand that we grew up in a culture where creativity may not have been seen as a job or practice or as a serious practice, but we need to shift, have a mindset shift and understand that what comes out of that process is in fact assets that carry economic labor. I mean, assets that take labor and have economic value. And, you know, as we speak more and more about transitioning towards knowledge-based economies and the likes, those are going to hinge largely on creative labor, on intellectual property, and et cetera, et cetera. No.
So we've just had another question that popped in,
right?
Where someone was asking, if you do patent something in Botswana, does that protect them outside of Botswana?
Right. So Botswana is a member of the Patent Cooperation Treaty, which means that a patent that is filed here could be applicable elsewhere, right? Could. So it's that when you apply for a patent, it's because it's a jurisdictional thing. It depends from country to country. You have to specify where you want your patent to apply.
To operate, yeah.
Right. So if, for example, I make a patent for, I don't know, this particular product here that I keep coming back to, if I apply for a patent for this particular product here, and then I want that patent to apply in Botswana, I want it to apply in South Africa, I want it to apply in Namibia. Right. So it may be applicable in Botswana. However, there may be another patent in operation in Namibia that I come into conflict with. And maybe I just want my patent to be protected in Botswana only. Yeah. So these are all these different considerations that come into play. But because of our subscription to international treaties and our membership of international organizations like the World Intellectual Property Organization, things like, you know, patents, trademarks have that broader application, not just to Botswana.
So what you're saying is someone shouldn't just go to some random patent thing or Europe and find ones that are just applicable for Europe and then that it's a little bit more complicated.
It's a little bit more complex than that, yes.
Okay.
Yeah.
Yes. So I would like to say thank you. I think I've learned a lot. I've actually been, I think I'm a lot more comfortable with what CEDA are trying to do. Mm-hmm. And I think, you know, the next step that I think we will probably look at with CEDA is to have someone who is on the CEDA team, who will practically sort of say, as you said, there's a few gray areas, and just try to find how they will sort of be treating all of this and how they're thinking about it in that sense, and then explore it from there so that it can be a lot more practical for this. So I'd like to thank you for your time.
Thank you for having me.
Any final words? Where can they reach you? We've had quite a lot of inquiries of people who want your assistance. Where can they reach you?
We're available on all platforms, I believe. We have a website, www.parkgrey.com. Parkgrey is PARKGREY.com. And then, so that's parkgrey.com, or you can email me at moremi@parkgrey.com, or we're on Facebook, Twitter, Instagram at parkgreyip.
Thank you. I'm hoping that, you know, by the end of the day, you'd have like 20, 30 inquiries. So I'd like to say thank you today for joining us. Thank you for the questions from everybody who's come on. I hope it was useful. It was certainly useful to me. And we will meet hopefully in the next few weeks as we keep going into the other sectors, but also, as we settle people in CEDA to find out what more that how they're looking at all these things, especially for creatives and what they can do for you. So with that, I'd like to say thank you for joining us, and hopefully see you soon.